well-known, Alex Magaisa. Welcome, Alex. Just show us, Alex. Evan, I want to see Alex.
Okay.
Alex.
Yes, I'm
Alex.
here.
Want to see you.
Yes, I'm here. Thank you.
Alex Magaisa, well-known legal expert, but also now established his reputation with the big Saturday read. Is enormous, a man of enormous energy, and has been on this forum several times. We thought we'd bring him here for this particular one. To help him, we have Thompson Chengeta, an international law expert, another Zimbabwean, ex-MS Midland State University, Harvard Law School. Welcome, Thompson.
Thank you very much.
Yeah, it's nice to see you. Welcome. Now, I'm not going to try and introduce a subject, especially since we have people much more able to do so, but simply to raise the concerns as a citizen. In the last few years, but particularly so since the 2018 elections, the judiciary in Zimbabwe has been on the spotlight because of allegations of partisanship and worse, political interference and so on and so forth. But this is not new on the African continent. We have had precedents in Kenya, where the Kenyans in particular virtually dissolved the entire judiciary and judges that reapply. And people are suggesting that maybe the same is necessary for the Zimbabwean situation, so bad as it become. But let me turn now to Alex Magaisa to introduce the subject. Alex.
Okay, thank you very much. I am going to screen share my presentation so that members of the audience can follow as I do my presentation on this subject. So if you could just bear with me as I do so. Okay, so I teach law for a living. We have been using Zoom and many other platforms in the last few weeks, and so it has become natural for some of us to prepare PowerPoint slides as a way of delivering the information that we have. I find that it works very well, and I hope it will work very well for this session. May I also ask members of the audience to please mute your mics, because if your mics are on, it will give feedback to me, and it will disturb the flow of the presentation. So this is an announcement that I make with my students, and I make to you on this occasion. Now, the topic of judicial capture in Zimbabwe, whether or not it's a myth or a reality, is something that is uppermost in the minds of many people, many Zimbabweans, I believe. My starting point is to just chronicle a few things that have been observed in the last few weeks. And currently, the current attempts to remove Justice Erika Ngewere from the High Court bench, the list of complaints that we have seen from her, challenging the style of leadership of the Chief Justice and the handling of the matter by the Judicial Services Commission, the letter of complaint which has been attributed to the judges, it was unsigned, but it was also not disowned as far as I'm aware. Whatever the case may be, the letter seems to have captured a number of things that have been rumored as coming from judges, indeed complaints about their working conditions. It also comes against the background of rejection of the Chief Justice's attempts to impose a supervisory model on judges in terms of their judicial decision making. The judges were correct to reject those efforts to oversee how they make their decisions. We're also seeing a frequent use of the removal procedure under the Constitution, both of judges and the prosecutor generals. We have also seen an increasing use of lawfare against political opponents, and therefore the courts or the judiciary becoming an important arena of resolving political disputes. And a number of techniques and strategies, such as deliberate delays in handling matters involving criminal allegations, denial of bail in situations where there should be no denial, conflict of interest. We are also seeing an increasing use of selective application of the law. The cases of Hopo Chingono, the journalist who is currently in jail, who has been denied bail today, in contrast to the very lenient handling of cases involving corrupt or allegedly corrupt individuals such as Obadiah Moyo, Deputy Minister of Health, John Mangwiro, and of course, more recently, Ms. Mshwaya, who is also in custody on allegations of gold smuggling, but getting treatment that is markedly different from the treatment that is being given to journalists like Hopo Chingono. We are also seeing the handling of opposition cases. It is well known by lawyers, by anybody who cares for justice, that like cases must be treated in the same way. When as RPF MP Kudakwashe Basikit, or then as an MP, challenged his removal from Parliament in 2015, he was told that these were internal matters that should be resolved at the party level. But when an NDC member challenged a similar, brought up a similar challenge, the courts were all too willing to hear this matter. Now, it may be that one case was handled correctly and the other wrongly, but the point is, like cases must be handled in the same way. And it is because of this and many other cases which have come before the courts with the disagreeable results that many people have begun to talk about the phenomenon of judicial capture in Zimbabwe. Now, whether or not this is correct, this is something that I seek to examine during the presentation of this paper. And Dr. Thompson Chingeta, who will come after me as a discussant, will have something to say about that as well. Now, I want us to have a fairly objective analysis of this phenomenon. This is not just an exercise in making allegations against the current judiciary or indeed against the government. That is not the purpose of this presentation. This presentation seeks to present an analysis of what we understand by judicial capture and whether or not it is indeed a phenomenon that we are seeing in Zimbabwe today or that we have seen in the past. Judicial capture is the antithesis or the opposite of judicial independence. In other words, we expect judges to act in an independent and objective way. When a judge is said to be captured, it means that the judge is now under the control and direction of another external interest. There are at least two conceptions of judicial independence, the one that perhaps is narrow, the other one broader. A narrow conception of judicial independence is one that says that the judiciary should be independent from the executive. In other words, it looks to the political independence of the judiciary within the broader conception of the principle of separation of powers. The broader conception, in my opinion, is one that looks beyond the idea of separation of powers and therefore looks at the independence of the judiciary from a wider range of actors and interests beyond the political. And I look at this as broader judicial independence. And the reason why I make this distinction will become clearer in a short while. Now, the judiciary is independent when it is serving what we might call the public interest. And I say so with the qualification that among lawyers, we have lots of dispute as to what constitutes the public interest. But I proceed with the assumption that the public interest that judges are supposed to serve is the delivery of justice. And therefore, not just the private interest of a select group of individuals, or indeed just individuals. A few years ago, when I wrote an article which I titled A Brief History of Judicial Capture in Zimbabwe, that was in 2016, I defined it by saying, I use the term judicial capture to explain a situation in which a segment of society has gained a disproportionate amount of influence over the judiciary, so that instead of serving the public interest, the judiciary ends up serving the interests of that particular segment. So that is the framework or the conceptualization of judicial capture that I use here. I will bore you a little bit, but this is important, you see, for us to understand the theoretical background of understanding capture. There is a theory called regulatory capture theory. What it means is that a body that is exercising public power in the public interest may become captured instead by private interests, so that instead of saving its mandate in the public interest, it begins to save the private interest of a few. And in that case, there is a subversion of the public interest by private interests. And as I've already said, in capture theory, while the judiciary is supposed to serve the public good of justice, it ends up serving partisan interests of specific individuals or groups, leading to the opposite of justice, which is injustice. And in this way, the judiciary becomes captured, in which case it is serving the private interests. You will see that in all this that I've done so far, I have not attributed any responsibility to the private interest. I have not named anyone. I'm simply setting out a broader conceptual understanding of what capture means. We can then fit in whom we think to be the one who is capturing and who is not capturing. And some of it will begin to emerge as I proceed with the presentation. So let us look at some of the more practical aspects as to how capture occurs. How does capture occur? Number one, capture occurs when there is disproportionate power between the captors and the judges. In other words, those who are doing the exercise of capturing have a huge amount of power over the judges. And this can manifest in at least three ways. Number one, it is through appointment. Now, if you are the appointing authority, and you can choose to pack the court with loyalists. This is what is often referred to by lawyers when they talk about packing the bench. What they mean is that the one who has the power to appoint has appointed people who are loyal to him or her. He is packing the court. In some ways, you may also see this by an attempt by appointing authorities to change the rules. They change the rules of appointment. So to give you an example, in the 2013 Constitution, there are rules which were created in order to ensure that the appointment of judges is done with public participation, public interviews of candidates, and then the president would only appoint persons who have been recommended to him by the Judicial Services Commission. But what we have seen with Constitutional Amendment number 1 and now Constitutional Amendment number 2 is an attempt to change that process in regard to judges of the Supreme Court and judges of the Constitutional Court. What would happen is that the president would have more unlimited power to appoint current judges to the Supreme Court or to the Constitutional Court. By changing the rules in this way, it allows or facilitates for a process of packing the court So that's how it is a process by which capture happens, because the courts then become captured by the appointing authority who is acting without any checks and balances. That's number one. Number two is compensation. Many constitutions around the world, if not all of them, create conditions that ensure that the judiciary is compensated in a manner that is befitting their office, that judges are able to live a life that is commensurate with the office they hold, and that their salaries are therefore not reduced by anybody. Because if you allow for that to happen, it means that the person who is appointing them or compensating them will capture them. Now, one of the ways, of course, to create conditions of capture is to create what I call conditions of judicial poverty. You can talk to all these judges who are serving today, none of them is happy with the compensation that they are getting. None of them is happy with the conditions of service that they have to contend with. Now, we are creating conditions that enable a capture of the judiciary, because now they have to beg from the government in order for them to live a life that is commensurate with the office they serve. By creating conditions of poverty, you are creating conditions that allow for capture. Number three is removal. If you make the removal of judges easy, as we are seeing now, especially if you allow for judges who have been referred to a tribunal to be suspended without pay or benefits, then you are creating conditions of fear among the judiciary. You are even, putting them into conditions of judicial poverty worse than they are when they are serving. So you can imagine the case of Justice Ndewere. Clearly, there are lots of illegalities. We won't get into much detail in that. I've already written on the reasons why I believe that hair suspension without pay and benefits is illegal, because it is not permitted by the common law. It is not permitted by the Constitution. The important thing is to understand that it is a message not just to Justice Ndewere, but it is a message to all the other judges who are serving either in the High Court or in the Supreme Court, and also, of course, in the Constitutional Court when they are appointed. Self-interest is another reason why there may be capture. Once you begin to align the interests of the judges and the captors, so for example, aligning the interests of the judges and the politicians, you now have a class alignment or ideological alignment. We can talk in more detail, perhaps in the Q&A session, about how the land revolution, how business interests, converted the position of judges. I always look back to that judgment, that famous judgment in 2015, when the Supreme Court held that labor law allows employers to fire employees without giving them a notice. After so many years, when everybody had thought that things were otherwise, as a decision that was also influenced by this ideological realignment that had taken place, especially with judges having become part of the landed class and therefore the employers. Furthermore, how does capture occur? Corruption. You simply corrupt the judges, recruit judges into the racket. I have a very good example of the RBZ farm mechanization scheme, the one that we disclosed in July this year. We saw the many beneficiaries of that, including religious leaders, political leaders. We saw business executives, but among them we also saw judges of the High Court and the Supreme Court. Now, once you corrupt the judges, how then do you expect them to be independent from those who are corrupting them? So corrupting the judges is one way in which you create conditions of capture. I've only given one example, but there could be even much more that is out there. But this is also created by conditions of poverty that I referred to, because if you ask the judges, they will say that, look, we are not being compensated. And if the government comes up and says, here is a tractor, here is a combined harvester, they're probably going to take it. Another mechanism of creating capture is autocratic rule by administrative fear. I've already mentioned the complaints that have been raised by Justice Ndewere, but she is not alone. Other judges are raising the same issues. concerning complaints about the Chief Justice's method of administration of rule, which appears to be autocratic. That way, you instill fear in the judges, instill fear in those who are in charge of the system, and therefore create conditions of capture. I will talk about the breakdown of unwritten rules. There are certain norms, certain traditions, certain conventions which regulate the relationship between the executive, between parliament, between the judiciary, between these three arms of the state. They include values such as respect, mutual respect, such as forbearance. Forbearance is an important principle which says, even though you have the power that you can exercise, but you can hold back and not use it. You use it only when it's absolutely necessary. This is why I have serious concerns about the now regular use of the removal procedure under the Constitution. It is perfectly lawful. The Constitution allows for that to happen. But as I pointed out, one of the reasons why you don't see this being used all the time in many countries is because of these norms, traditions, and conventions that regulate the behavior or the I don't know if you can hear me. I got a sign that I've been muted. So
yeah, you can hear you. Can hear you now.
Excellent, excellent. I was rather in full flow there, but let me go back. So the other problem is over familiarity between judges and captors. You know, there is a certain way in which the judiciary must relate with parliamentarians, in which the judiciary must relate with those who are holding executive power. When you see over familiarity, when you see a friendly demeanor approach between these two, it raises some concern. There are things that they can do out there in private, but the moment it starts showing in public, then it raises all manner of problems. But of course, capture does happen. These people meet in the same spaces. They probably attend the same golf clubs. They probably, engage in the same activities, social activities. There are interconnections in their private lives because they are elites. They are political and judicial elites, and that can become a problem. That can lead to capture if there are no boundaries between these actors in the different arms of the state. You can say the same thing as well about the military, about the executive, parliament, and others. There has to be a healthy distance between these actors. We can talk about the revolving door phenomenon. Perhaps it is not such a big problem in Zimbabwe at the moment, but it may be a revolving door. It means when you are part of a regulator, you sometimes go back and work in industry. Sometimes you come back from industry, go back to the regulator. Now, this could be an issue where you've got judiciary members and politicians perhaps changing from one point to another. There is not much evidence at the moment for this to say this about Zimbabwe, but certainly it's an issue that one would be concerned with if it became the norm. The next right. Okay, so the indicators of capture. The indicators of capture, at what point do you say that we are seeing judicial capture? Number one, it could be when you see there is systemic or institutional bias for private interests. So you begin to see a consistent approach towards judicial decision making, where one side tends to get favor and the other side, especially political, is treated in a manner that may be deemed to be unfair. And then certainly in Zimbabwe, I think there have been so many noises about bias or institutional bias or systemic bias of parts of the judiciary or the judiciary as a whole. It may not be unfair. It may be unfair on the whole judiciary, but certainly some parts of the judiciary may be guilty of promoting or acting in a manner that might be described as institutional bias for specific private interests, in this case, private interests of a political party such as ZANU-PF. You can see capture when you see predictable outcomes. You know, when people go to court, when Hopo Chimono goes to court, and 9 out of 10 people tell you that he is not going to get bail. Not because he has a weak case, but because they are now accustomed to the fact that this is how the system works. 9 out of 10 people begin to say catch and release. Now, the government may be unhappy with the use of such terms, but it must be concerned that people are using such terms, that such terms have become part of the Zimbabwean vocabulary. It shows you that the judicial system has become so predictable, and that's one of the indicators of capture. You may also see seemingly positive outcomes, but these positive outcomes are often diluted. You know, this is one of the reasons why I started writing the Big Saturday Read. It was for me important to demystify some of the things that were coming out of the courts. I would be very disappointed when I saw colleagues, even lawyers, celebrating decisions coming from the High Court or from the Supreme Court as an advancement of human rights, when in fact, when you look at the judgment, the terms of the judgment, you see that the court has given with one hand, but has taken away with another hand. Now, this is something that you see in conditions of capture. They will give you an appearance that they're doing something positive. But when you actually look at the judgment in a critical way, you see that it is completely the opposite of what people are thinking. You can also see that there is capture through the rampant selective application of the law, depending on the status of the accused. I've already given examples of more current cases that we are witnessing. Hopo Chimono, Henrietta Rushwaya, John Mangwiro, the Deputy Health Minister. You hear that he is being accused of corruption. He's never arrested. He's not in chains. Hopo Chimono is arrested. The man is in chains. He's in leg irons. He's placed in Chikurubi. You see the selective application of the law depending on who the accused is. And once you start to see a pattern, then you can begin to identify indications of capture. You can also see that there is capture taking place through a culture of fear and submissiveness. Now, I admit that it's probably very difficult to measure a culture of fear or submissiveness, but this is something that you can see, something that you can observe by the way that the courts operate, by the way in which the courts behave, judges behave. It used to be the case that people focused a lot on the High Court and the Supreme Court. But now, a lot of people are talking about what's happening in the magistrates' courts, because it seems that this culture, the institutional bias, the delays, the lawfare mechanisms have now spilled over not just to the Supreme Court, but also to the magistrates' court. Another sign of capture, and this is very important, lawyers, political scientists and others who study the patterns of power, is the absence of dissent in judicial decision-making. Now, there are many people here who are not lawyers. Let me just explain a little bit. Whenever there is a case which comes before a panel of judges, such as you have with the Supreme Court or the Constitutional Court, each of the judges is expected to have an opinion on what has happened in the matter, on the decision. Very often, you will find that if there are 5 judges, 3 of them might agree on an outcome. They might even agree on the reasoning that is being used to support that particular outcome. But you might also find that 2 of them might have a different view on the matter. They might even agree with the outcome, but they would disagree with the reasoning. Sometimes they might even disagree completely with the outcome and the reasoning. That's what we call a dissenting judgment. If you look at any decent constitutional court or Supreme Court around the world, you will find that there is almost always a dissenting opinion in major cases, especially in controversial cases. Now, if you look at the Zimbabwean bench, you would have to struggle to find cases where there is a dissenting judgment. I don't know whether it's because judges are coerced into having some consensus on a particular judgment, or whether they are lazy, they just don't have the appetite to read and research and give their own opinions, whether they simply have no clue what to do. They just have to admit. You know, when I was in law school many years ago, we used to laugh at particular judges who, every time, whenever you read a judgment, the only thing that they contributed to a judgment was a very short statement saying, I concur. In other words, I agree. They had no opinion of their own. They never wrote any judgment of their own. And this is the point. Once you see the absence of dissent and it becomes systemic, it is not an accident. It is something that is a pattern. Then there is something wrong with that judiciary, because there should be someone who has a different opinion. Lawyers never always agree on anything. Very often there is disagreement. It is shocking, therefore, that you find our judiciary agreeing on almost every decision that is made. And very often that decision is given by the Chief Justice of the country. Now, I have said a lot concerning conceptual issues of judicial capture, concerning how judicial capture takes place, and some of the indicators that you look for when you're looking at judicial capture. The way that I had conceptualized this paper was that I wanted also to give you an understanding that when we are assessing judicial capture, we are not just focusing on the current judiciary. Go back to the first 20 years of independence. In the first 20 years of independence, what Zimbabwe did was that it inherited a judiciary from the colonial regime. However, some very highly unpopular judges of the time, including the so-called hanging judge, as he was called by the nationalists, Chief Justice MacDonald, left the bench in 1980. But otherwise, the majority of them were judges who had served during the colonial period. The reason why they were retained was, of course, part of the package of reassuring the white minority population, and that the country was also for them. You will see that there were similar measures which were put in the constitution regarding parliamentary representation, and there was the division of the white role and the common role, which allowed the minority white population to have representation in parliament. You could see similar measures being taken place in the judiciary, although this was not written in the constitution, it was a political decision. But it was also because of a lack of confidence in the lawyers, the black lawyers of the time. Very few of them were experienced enough to take on that role. And this is why you find that we actually imported judges from countries like Tanzania and from some friendly Caribbean countries who came in to fill in gaps. And there was some affirmative action, hence you saw Justice Nwachena coming in 1981, and he went on to become a great Chief Justice for Zimbabwe. Now, in the first 20 years, the biggest clash between the judiciary and the government was over state security and human rights. The government was not happy with the acquittals of former Zipra commanders, Tumiso Dawengwa and Lookout Masuku. They were not happy with the acquittal of the 6 white officers of the Air Force of Zimbabwe who had been accused of masterminding the bombing of the Thoni Air Base. These decisions led the then Minister of Home Affairs, Dr. Herbert Ushokunze, to accuse judges of showing class and racial bias and of not being in tune with the government. The Tekere trial in 1984, in which Edgar Tekere was acquitted, but he was not happy with the white judge, Justice Pertman, whom he accused of having been racist in the case. What made the difference at the time, but maybe before I go into that, let me just talk about the case of Ian Douglas Smith. Ian Douglas Smith had made some comments in South Africa, which the Zimbabwean government did not like. When he came to Parliament, he was charged with contempt, and he was stripped of his pay and benefits by the Speaker of Parliament. This decision was reversed by the Supreme Court. However, the Speaker of Parliament at the time, Didmus Mutasa, was not very happy with the way things had happened, and there was a serious clash between the Supreme Court and Didmus Mutasa. But I'm happy to point out that the key actors that made a difference in that case, which eventually restored the position to what it should have been, was that the judges themselves got together and issued a collective statement defending their position. Judges often don't come out to defend themselves, but in this case, they did. The Law Society of Zimbabwe also joined in. The academic community at the University of Zimbabwe, the Faculty of Law, also issued a statement defending judges. And of course, members of parliament also came in and voted in order to protect Smith's wages and benefits and to respect the decision that had been made by the Supreme Court. Of course, someone might say the members of parliament were like turkeys. They could not have voted for Christmas. You know, if the decision to suspend Smith without benefits was going to be upheld, it would also have applied to them. So they had no interest in ensuring, even if they didn't like Smith. But it was fascinating that this was a parliament which consisted mainly of ZANU-PF, but they actually voted in order to overrule what the speaker wanted to do. These are the things that made a difference. Remember what I mentioned about norms, about rules that protect the relationship between these arms of the state. I should also, this is a very important statement which I picked up, which was issued by Prime Minister, the then Prime Minister, Robert Mugabe, which shows again those norms of cordiality, respect, and non-interference with the judiciary, which was quite common during that period, despite the clashes between the government and the judges. And this is what he said in 1984. Some members of the executive have publicly criticized some decisions by our judges, but the government as such has ignored these criticisms, preferring to treat them as the exercise by those concerned of their freedom of speech. The government has not, qua the government, by word or deed, interfered with the independence of the judiciary. So this was Robert Mugabe in 1984, making a very bold statement that even though there were some of his ministers who were being critical of the judges, his government itself respected the boundaries between the government and the executive. Now, fast forward to 2000 in December. This is again now President Robert Mugabe speaking at a ZANU-PF conference, and this is what he said. The courts can do what they want. They are not courts of our people, and we shall not even be defending ourselves in these courts. These courts can do whatever they want, but no judicial decision will stand in our way. Now, you've got two different pictures of Robert Mugabe here. The first picture is of a Robert Mugabe who has been very cordial, who is respecting the norms, the traditions, and conventions of the relationship between the executive and the judiciary. And later, 16 years later, you've got a Robert Mugabe who is basically saying, you know, for lack of a better phrase, to hell with the courts. We're not going to respect them. We don't respect them. Now, the question is, why did this happen? Right. The reason why this happened, of course, was because at that time that President Mugabe was making that statement, that was at the height of the, what I referred to as the land revolution, the fast-track land reform program. The politics had changed, and it was a position which was defensive of what the government was doing. I want to make reference to why this was happening. It was because the government itself, ironically, actually believed that the Supreme Court of the 1980s and 1990s had been ideologically captured by white farmers. So that was the view of the government. Let me make a reference to one incident that caused a real problem between the government and the judiciary in 1991. It's often referred to as the essential features speech. when then Chief Justice Anthony Gabi made one of the speech at the opening of the legal year, and he made comments concerning, I think, a bill that was due before Parliament concerning the land reform program, which the government wanted to undertake. And Chief Justice Gabi, mentioned that there are certain features of the Constitution which are so essential that they cannot be changed without affecting the whole foundation of the Constitution. It's a doctrine that emanates from the Indian courts. Now, he said, in part, it is the duty and function of the judiciary to protect the Constitution against such change. Now, those of you who are old enough to remember what happened at the time, this caused a real problem. Mugabe even called on the Chief Justice to resign if he did not like the laws that were going to be made by Parliament. This was, in my opinion, a seminal moment in the relationship between the two. It was interpreted as a political speech, which was designed to reassure white farmers that they would not lose their land, that they would be protected if they went to court. At least this is how, I'm not speaking my words, I'm speaking the words of what was coming from the government. And in fact, the Chief Justice who succeeded him later on made another speech in the 2000s, which made reference to this particular 1991 speech. The point I'm trying to make here is that in the eyes of the government, the judiciary at the time was captured by minority interests of white farmers. Whether or not they were right or wrong is not the issue. The issue is to tell you, is to put it on the table that there was a belief that the judiciary was captured. Likewise, if you look at the left, it would be remiss if I did not mention scholars like Captain Makamure, S.P. Oguto, Mnyarati Bisai, who is still at the University of Zimbabwe, who believe that the Supreme Court had in fact been captured by capital, that it was serving or pandering to the interests of capital and the petit bourgeois. Bisai had a very critical comment on how the Supreme Court had legalized or legitimized a decision by the government to stop or suspend paying bonuses to civil servants in the late 1990s. And he believed that, or at least he argued, that the Supreme Court was pandering to the interests of the government. So it was capturing someone. So I put it there in question marks, captured by white farmers or captured by capital. You can see what I'm trying to do in this presentation. I'm trying to give you the multiple dimension of capture. That capture is not just a political phenomenon. That capture can also come from other sources, or indeed it can be seen as coming from other sources. The major changes that took place in the 2000s, remember I talked about the opportunities for capture, when you start removing judges, when you start packing the bench. This is how Chief Justice Gabi described a scene in the early 2000s, in November 2000, when the Supreme Court was invaded by a mob which was led by Joseph Kilotimba, who is now a member of parliament in Zimbabwe. The mob shouted political slogans and even called for the judges to be killed. They stood on chairs, benches, and tables in a show of absolute contempt for the institution of the courts. Such deplorable behavior sent the clearest message that the rule of law was not to be respected. The invasion lasted an hour. The outcome of this was that the then Minister of Justice, Patrick Chamasa, told the judges that the government could no longer guarantee their safety, and this forced the Chief Justice into an early retirement. Fascinatingly, and this is the point I make at the end, for the government, it believed that by changing the complexion of the judiciary, it was reversing judicial capture. But on the other hand, and this is where this journey that we are on now begins, it was also creating a new form of judicial capture, and which is what we now have. I hope now you can understand why I started the historical trajectory from 1980 to the 2000s. and to where we are now, because you've got to draw the linkages of what transpired then. So if the accusation by the government against the Gabi bench was that it was captured by the private interests of white farmers, the new judicial bench was well on its way to being captured by the private interests of ZANU-PF's political elites as the primary beneficiaries of the land reform program. This was also reflected by the stark difference in the rulings over the legality of the land reform program. What the Gabi Supreme Court said, the Judicial said completely the opposite. The Judicial Court was playing a distinctively political role as the court of the land revolution. And it's interesting that I'm taking this paper a day after the 65th anniversary of the UDI. In my opinion, the Judicial Court was no different from the way that the post-UDI courts behaved. They essentially legalized and authorized what the legal government had said, and the Judicial bench did precisely the same. I like to do these things because you demonstrate some of the continuities between the before and the after. A fascinating exercise. So we've now had what you might refer to as political capture. The judiciary's role in mediating the relationship between ZANU-PF and the MDC, leading to the charge that it is a biased political referee. The packing of the bench, I've already made reference to that after 2000. The alignment of ideological interests, the land, human, and the politics of land and power brought the judicial elites and the political elites together. They were both beneficiaries of the same and therefore had an interest in defending it. The handling of electoral disputes, if the MDC was seen to be the opposite of what ZANU-PF represented in the third politics of land and power, therefore it is not surprising that the judicial elite tended to sway in favor of the ZANU-PF political elites. Then, of course, we talk about selective application of the law. I should mention, as someone who sat at the table during the constitution making exercise, that the MDC really wanted, because it believed the judiciary had been captured, it wanted the judiciary to be completely overhauled. And it wanted to take the approach that had been taken by Kenya in 2010, whereby all judges had left office and they had to be interviewed in order to form a new bench. That's what the MDC wanted to happen. Unfortunately, and I say unfortunately because some of the consequences of what we see today are a result of MDC losing that war, or that battle. We lost that battle because I was part of the team that was negotiating with the MDC, and politically the MDC was unable to get the reform of the judiciary in the way that it happened. So this was, for me, not surprising that in 2013, when Morgan Tsvangirai wanted to challenge the result of the presidential election, I and a few other people said, look, this is a waste of time. You are going to a court that has judges who know that you wanted to remove them from their offices. They are not going to judge fairly. It's a waste of time. And it has been for a long time because of that. These judges, at least that generation, knows that the MDC wanted to remove them from office. They're never going to be fair to the MDC. Part of that capture is also in reverse. If the MDC had taken that position, then they should have really, it should have succeeded. It did not. And that failure has continued to haunt the opposition to this day. So when you talk about judicial independence, as I mentioned, may I ask you to mute your lines, please?
Hi, baby.
Right. Okay, I would just have to talk of, I think there's a lovely baby who is talking in the background. I'm not sure. She's part of the audience. So I wanted to say that, for us to understand judicial independence and how it works, it is something that we construct in our minds. It is a social construct. Social constructs are very important in the organization of society and how it is governed. It's a creation of our imagination. We want judicial independence to exist. But the only way that this independence can exist, this imagined reality of independence, the only way it can exist and survive is when people believe in it and when people are prepared to defend it and to stand by it. When I say people, I'm not just talking about judges. I'm talking about lawyers. I'm talking about politicians. But I'm also talking about the generality of the people, the public. After all, if you read the Constitution, it says that judicial authority derives from the people. Now, many Zimbabweans might not even know that, but that is what the document says. And it is the people who must believe and defend judicial independence. When you see things that are happening to people like Justice Zimbabwe, when you see the mishandling of cases, the mutilation of justice, in the case of Wobo Shimori and others, and we just tweet and Facebook and say that we are going to pray for them. We are as a people abdicating our responsibility. Judicial capture is not going to be undone by the things that people talk about. It's not going to be undone by prayer. It is going to be undone by people being active in their defense of the judiciary and judicial independence and people like Justice Zimbabwe. Whatever she might have done, she deserves to be treated in a fair manner, which is not happening. But it's not enough to just make statements. There are key actors, as I said, the military, business elites, members of the public, judges. They must all believe and uphold this myth. Once we break down these unwritten rules, the norms, traditions that will hold the whole package together. You know, the Constitution has provisions, our criminal code has provisions such as perjury, contempt of court. These are rules which are designed to protect the judiciary. People must see the judiciary as a space which you cannot just attack. You know, if you are going to attack it, you must have the facts. And when I talk about judicial capture, that's why you see me going down through the evidential path, picking up the cases, picking up the history, and showing where we have come from and explaining how things have been and where we are. But in particular, while criticism of the judiciary is necessary, it is also important to ensure that those in positions of power, the politicians, in particular the executive, they are restrained in the way they deal with and approach the judiciary. And it is up to the people to take that position. That's why I talk about the power of unwritten rules, the power of forbearance, the power of mutual respect and toleration, the power of having the convention of non-interference, that as an executive, you really have to respect these taboos and conventions around the judiciary. I always tell people to read a book by Levitsky and Ziblatt called How Democracy is Done. It is, of course, talking about the American politics, but it's so fascinating, very useful in trying to understand those things that are not written, things that are part of the political culture of a society, which are absolutely important in keeping things together. And I think they are important in helping us to understand how we can undo judicial capture and how we can enhance the protection of judicial independence. So this is what has happened to us in Zimbabwe. I could go on and on and on. I think I have covered in much detail the various things that have happened since independence and we have gone to before independence, where of course I've intimated that the judiciary itself was captured by the government of the day. Then there were attempts to change things in the 1980s, in the 1990s. Even Robert Mugabe, he had an opportunity to appoint a black judge as the Chief Justice of Zimbabwe in 1990 upon the retirement of Chief Justice Judicial. But whom did he appoint? He actually appointed Chief Justice Gabi, who had been appointed from the colonial era. That was an old age ago. But you know what? In the 2000s, the same people who appointed these people were now disowning them, saying that they were colonial judges. They were not our judges, because it was not convenient. But that was the beginning. Those were the beginnings of the capture that we now see today. Dr. Chengeta will talk about the more current cases. I've been very careful not to go into much detail about the coup in November 2017, because I don't want him to repeat things that I would have said. But of course, we see, of course, that there is also a capture that took place with those judgments, which were very partisan in defense of a military coup, and therefore were certainly not justice, but the private interests of the military, or what you might call the coupists. And it is, of course, the private interest of the coupists that we're now seeing in play today. Dr. Mandaza, I'm going to stop here for now, and then let people digest as they listen to Dr. Chengeta, and then perhaps there will be lots of questions which will help us to fill some of the gaps that have been left from the presentation. It's been a pleasure. Thank you.
No, thanks, Alex. You gave us a long outline, historical, but punctuated by illustrations. It was long, but I think necessary. It was academic, I think useful. And already we have a large collection of people on the Zoom, almost 300 people already. So this is a very, very provocative subject. And of course, as I said earlier, very current. I won't try and summarize what you have to say, but I think some of the issues which have come up, the selective application of the law, the use of lawfare against political opponents, and so on and so forth. I should add here for our viewers that the backdrop to this is not only the nature of the states that we have, and I believe Thompson Chengeta will be elaborating on that of the period since the coup, but it's also the recent, there's been a document purporting to be complaints by judges against the Chief Justice. And today we saw a repeat of that in one of the cases concerning a judge who's being suspended. So it's becoming very current, and regrettably the Chief Justice is in the limelight, in the spotlight. So Thompson Chengeta, can you join us now, please?
Thank you very much, Dr. Mandaza, for the invitation to act as a discussant following Dr. Magaisa's excellent presentation and very detailed on the issue of judicial capture or judicial independence in Zimbabwe. So I would probably have simply stated that I concur with Dr. Magaisa and then leave it there. But given his comments, which he has already given, that sometimes the issue of concurring without giving reasons why may be interpreted as capture. I don't want this to be interpreted as academic capture. So I will therefore, in maybe about 6 points, try to argument some of the things that have been discussed by Dr. Magaisa and why I believe that they make sense and they are fundamental to our development towards a more independent judiciary. But in doing so, I'll also highlight some points which perhaps I'll in a way try to have some sort of pushback to have other explanations from Dr. Magaisa. The first question which I want to deal with is the aspect of the conceptualization of the point of judicial independence as a critical norm. And I say this because I'm giving reference to the title of Dr. Magaisa's paper, and because of I've been reading around a recent book that has been published by Luke Marsh and Mike McNovell, and their book is titled The Myth of Judicial Independence, and it was recently published by Oxford University Press in August 2020. While I understand the idea of referring, for example, when discussing judicial independence as a myth, one of the things, at least from my view, which I would want to emphasize in support of what Dr. Magaisa was presenting is the idea that if one is to view judicial independence as a norm, I would say that it is not a myth. It lies at the core of justice, and justice is essential to what it means to be human, that is, humans with rights. Even though I may understand that at certain points within the history of any country, including Zimbabwe in this regard, there may be circumstances where one may feel that judicial independence is not being sustained or it's being attacked, there's judicial capture. That in itself does not make judicial independence as a norm, as an important norm, a myth as it were. That is the first point which I would want to refer to as far as conceptualization is concerned, but still supporting the points that Dr. Magaisa was making. The second point which I want to make before I go to the more nuanced substantive discussions relate to a point where I'm encouraging fellow citizens, ladies and gentlemen, to move from a place of polarity to constructive discussions on issues of judicial independence. It is important, and I cannot emphasize this point enough, that we move away from a polarized position where the moment an individual hear the discussion or hear the term judicial independence in Zimbabwe, the first thing that a person orient themselves or position themselves is, to which party do I belong? If someone is belonging to a certain political party, then they then take a stance according to the views that they may think support that political party. And I'm saying perhaps that approach is dangerous, particularly when it comes to consideration of judicial independence, because judicial independence is important, critical to all of us for so many reasons. But to highlight that importance, allow me perhaps to refer to one book that was once written. It's a play and then was made into a movie by Robert Bolt, A Man of All Seasons, where there was a conversation between William Roper and Sir Thomas More, where because of the political disagreements that were going on, William Roper, referring to his enemies as the devil, asked Sir Thomas More whether Sir Thomas More was willing to give the devil the benefit of law. To which Sir Thomas More replies, yes, I will give the devil the benefit of the law simply because I also want to ensure my own safety. Because if you destroy the law that is meant to protect everyone, and when all the laws are down and the devil turned against you, you have nothing to protect you. On the place of the law, I could place the issue of judicial independence. The moment you allow the taking away of judicial independence, simply because it may be convenient to you at a particular moment in time, when the time comes, I can emphasize that no one can forever stand upright in the winds of injustice that will blow when courts are not independent or are captured. And forever in politics, you can never ever be the one who is favored. The history of Zimbabwe, especially in recent, have actually made us aware of that. When it comes to judicial independence, and this is my second point, the crux of the second point, which I'm trying to emphasize here, is that I wish for a time where no matter how rough, no matter how ugly political battles may be, it should be possible for everyone, regardless to which party you belong, to still be able to approach the courts and seek protection where you are assured that the courts will be independent. In that regard, I wish and I pray that as Zimbabweans work together, that when it comes to political disagreement, it will be unnecessary, for example, that President Mnangagwa and the late President Robert Mugabe would disagree on a certain point, and the moment they disagree, President Mnangagwa had to run away to leave the country. I wish again for many other people who are doing the same, because these are some of the signs which you see that there is no perhaps a perceived independent judiciary that can play a part in protecting citizens as far as administration of, or acting as an arbiter when there are disputes. And in this regard, I would give an example where if you were to look at the politics of South Africa, the politics there gets ugly. The politics there gets rough. But you can see that between the EFF, between Malema, between Zuma and others, at least they remain to some extent, or to a large extent, if I may say, faith in the judiciary, that regardless of how ugly your disagreements can be, you are able to go to the courts and seek remedy and perhaps receive that particular remedy without fears that the judiciary is captured. Finally, on this point, I want to emphasize again, anchoring on what has already been presented by Dr. Magaisa, to say that usually when people comment or seek to comment on the independence of the judiciary or the capture thereof, some of the questions which you already receive, or some of comments which I was already receiving, is where people ask you, is it even safe to be talking about these things? The moment you arrive at that point, the worry is perhaps that fear which Dr. Magaisa was referring, that the judiciary or the political environment which we are operating in is not favorable to judicial independence. And if you look at the comments that were made by the Human Rights Committee, for example, in the case of Collins versus Jamaica, it is clearly stated that it is within the rights of citizens to challenge, comment, and criticize the impartiality of judges. It should not be a crime. People should not be victimized for doing so. I go to the third point regarding one of the fundamental aspects that Dr. Magaisa discussed regarding the broad conceptualization of judicial independence, something which I largely or maybe wholly agree with, mainly because if you look at the issue of judicial independence, in addition to try maybe to make to make the understanding there broader, I would also perhaps say that it is necessary to understand the concept of judicial independence and of the impartiality of judges and the relationship thereof. While these terms sometimes may be used interchangeably, there are nuanced differences between the two terms. For example, if we look at the African Charter of Human and People's Rights in Article 7, is the one which provides for the right to be tried by an impartial and competent court, and the issue of judicial independence being referred to as a state obligation, particularly being referred to or provided for in Article 26 of the African Charter. Independence in this framework is largely viewed to be broader and including the issues of functional and institutional independence, which Magaisa correctly and succinctly already developed and argued on. And when it comes to impartiality of judges, it referring specifically, for example, that when it comes to judges, judges must not harbor any preconceptions about the matter that comes before them. Why is it important for me to point to the issue of judicial independence and the impartiality of judges? Of course, independence of the judiciary, I emphasize, enhances the impartiality of a judge. But independence of the judiciary does not necessarily mean a judge will act in an impartial manner in a particular case. Likewise, the impartiality of a judge in a particular case does not mean in and of itself there is independence of the judiciary. Why is this point important to make? Because I have seen sometimes the exchanges that happen between scholars as far as independence of the judiciary in Zimbabwe. Some of them criticizing sometimes the standpoint of Magaisa has been referenced. There is the methodology they just referenced to say, well, how can you say that the judiciary is not independent? Look at this case, it was against the government. Look at this case, it was not favorable to the government. And those on the other side may also make the same approach to say, look at this particular judgment, it was not favorable, therefore, it means the judiciary is not independent. I think what is critical in as far as consideration of that methodology, as Omar Gaisa has completely explained, is the issue that do there exist a systemic problem where, when it comes to certain issues, particularly that are closely linked and tied to politics, that you see a certain kind of ruling happening. And when you are able to distinguish this, I think an example which I can then give on the aspect of difference between independence and impartiality. The case which Omar Gaisa was correctly referring to, that of Justice Ndewere, while one may actually be thinking, look, there's no independence of the judiciary in Zimbabwe, but you have a judge who acts in an impartial manner and decide to follow the law, for example, and perhaps give a judgment favorable to a person who is perhaps being politically victimized. Now, that judge has been able to act impartially, but yet at the same time, there's no independence of the judiciary where you then find that person getting victimized. That is the difference which perhaps in our discussion of trying to decide whether or not there is judicial independence in Zimbabwe or not, you may need to consider. And in regard to that, actually, it is also important then to consider aspect of what others refer to as de jure independence, that is independence provided in terms of law, which you can be easily able to prove, and de facto independence, that which is now more about how judges are acting. So you have the laws which say of Zimbabwe, which say the judiciary is supposed to be independent, judges are supposed to act in this particular manner, but where you find the Chief Justice, and with respect, making certain memos of how judges are supposed to act, then you then say that there may be no de facto independence as far as the judges are concerned. I want to briefly move on to my fourth point, which is regarding the aspect of recent Zimbabwean cases on political independence. Before I even go there, allow me to give reference to what was already said by one politician in as far back as 1958, that is Harold Laswell, when he said that politics generally is about who gets what, when, and how. And in the context of Omar Gaisa's methodology of saying, how do you see that there is capture or judicial capture, justice becomes part of that corpus, where you then say who is getting justice, when, and how. And the cases that have been referred by Omar Gaisa in this particular point clearly show where you say you may have cases that have similar effects, but perhaps being decided differently. The moment politics seems then to be controlling the courts or controlling how justice is administered, then that is an important point to note as far as the capture of the judiciary is concerned. I will not repeat the important cases that have been already referred to by Omar Gaisa, for example, the issues of the cases of Hopo Chingono, what happened even today, the cases of whether or not there was a coup in November 17 regarding the deployment of the army, and many other of such cases. But what I just want to add, not to be repeating myself, is particularly also international law that is binding on Zimbabwe regarding some of the concepts that Omar Gaisa was referring to. For example, when you look at the case of Justice Ndewere, I invite you fellow citizens, and here again, inviting you to dispose of any political affiliations, look at this issue as us beloved citizens of the nation who are seeking to build this nation together. To read the recent report by the United Nations Special Rapporteur on the independence of judges and lawyers, that was the 2020 report, and it is titled Disciplinary Measures Against Judges and the Use of Disguised Sanctions, where after consideration across the globe of what is happening, he articulates clearly the point that where you find that certain measures are taken, such as where you start depriving someone of their wages, depriving someone of their security, before even a matter has been determined, you have those being characterized as disguised sanctions that are not preferable when it comes to the independence of judges. And again, this is not a matter of whether or not Justice Ndewere was giving a judgment in favor of one political party or not. This is an issue which, again, I emphasize should be important to every Zimbabwean, every well-meaning Zimbabwean, to say it should not be acceptable that where a judge seems to give a judgment or has given a judgment that may not be preferable to certain political actors, then they end up being targeted, as it were. Now, one point which I want to add to the general discussion also, which Wamagaisa was making or emphasize, is the aspect of internal capture of the judiciary itself. So there are external factors which Wamagaisa was referring to, but when it comes to internal capture, I want to emphasize that usually when people talk about judicial capture, reference is usually to the upper courts, the judges of the High Court, the Supreme Court. But most of the dirty work, most of the injustice that we perhaps complain most of the times actually happen in the lower courts, in the magistrate courts. The denial of bail, which we're even referring, they happen at the first instance in the magistrate courts. The question being, what are the issues that affect the lower judicial officers in the magistrate courts? What is the relationship between the judicial officers within the lower courts and the higher courts? And that is what I may be referring to as internal capture. And that internal capture, I'm referring it to because it is important that sometimes, while you may assume that the executive already is involved, sometimes it could be an issue of also politics within the institution itself, which we need to be properly aware of. Finally, the point which I want to address, which I guess that it's something which I feel we need to be way aware of if we are to ever attain full judicial independence, is understanding individual limitations of judicial officers as capture. Now here, I'm particularly referring to something which we can call the myth of a non-human judge. Well, before I even discuss a little bit in detail of what I mean when I say the myth of a non-human judge, let me perhaps again, in my love for also literature, refer to you to Hamlet, Shakespeare's Hamlet, where you find Hamlet, when he was talking to Horatio, where he particularly says, there are more things in heaven and in earth, Horatio, and these things go beyond what you may dream in your philosophy. Particularly, this phrase is used to generally refer to limitations in human knowledge of things what you may think we know. That's why in the beginning of my intervention, I've highlighted, for example, to say that, of course, when I talk of judicial independence, the independence of the institution itself as a norm, I don't think it's a myth, whether or not it's being realized at a particular point in time or not. But when it comes to the independence of or the nature of judges themselves, I would agree that we should actually make sure that there is no myth about the non-human nature of a judge. And by referring to this, I think I should refer to some questions or to a text, which I may invite those who may have time to read. It is a book by Jerome Frank on Courts on Trial Myth and the Reality of Criminal Justice, and it is a 1949 book. In this regard, it gave me these questions which you have to talk about: intellectual capture, that someone can be captured by prejudice, that there can be philosophical capture, that there can be sociological capture, that there can be also psychological capture. And reason why it is important to, in addition to what Wamagaisa was discussing, to consider these factors is that usually when people talk of judicial independence, there is a temptation to be legalistic, to consider only legal from a legal point of view, as it were. Yet this is a multidisciplinary aspect. There is a need of multidisciplinary approach when you're talking about judicial independence. And I again refer you, for example, to the recent book. It's not recent, well, it's a 2002 book by Stephen Burbank and Barry Friedman, where, for example, they talk about judicial independence at crossroads and the need for an interdisciplinary approach. There are many, ways by which the issue of judicial independence can be enhanced or investigated, including the phenomena of what is going or currently going on in Zimbabwe. For example, when you talk of behavioral psychology, many psychologists actually have investigated this issue, where they say it's generally human nature to want to act in a manner that pleases those they respect. And when people try to act or in a way that try to please those they respect, they are being human, and judges are part of that humanity. Not wanting to go on this point, let me try perhaps to conclude this particular point by noting that while it is given that we must maintain utmost respect for our judicial officers, and I encourage everyone, because they play a very fundamental role in our society, to reduce, for example, but for us, if we want to reduce individual limitations of judges, it is important, at least on an intellectual level, for both judicial officers and the citizens at large to realize that judges are in fact, mere humans. As noted by one scholar, so to say, we have a tendency to believe that somehow the process of becoming a judge or a judicial officer effects a substantial transformation, and that judges become different from the rest of us. At least implicitly, we impute some kind of near magical properties to the acts of taking an oath and donning a black robe, as if they somehow eliminate one's susceptibility to all foibles, to weaknesses, biases, and petty jealousies that are the stuff of everyday life. This is not true. So the importance of actually noting that judges are humans and them realizing that particular point is that it is only when you realize your limitations that you are likely able to act in an impartial manner, that you are likely able to make sure that when you're making judgments, you are aware of your weaknesses and make sure that they are not actually being or finding themselves in the way of how you are applying the law or interpreting the law in that regard. Given the time, I do not want to continue going on, but at least to give back to Dr. Mandaza, and then answer any questions that may arise.
No, thanks very much, Ngeta. Thank you. I'm under extreme pressure here. There are people dying to get into the discussion. I have already Reggie Austin, Musa Kika, Sam Shia, Jonathan Moyo. We'll begin with that. Reg, are you ready? Reg Austin? Reg? Musa Kika, whoever's ready of those four, Zamshia or Jonathan Moyo? Hello? Hello?
Yes, hello.
Yeah, Reg.
Can you hear
Reg
me?
Austin, hi Reg, how are you?
I'm okay. Can you hear me?
Yes, I can hear you.
Yes. I think, first of all, thank you very much, both Dr. Chingit and Alex, for a very, very useful and academic, but very clear exposition, both of you. The thing which strikes me, and it's always struck me, is that fundamentally, the point that was made about independence as opposed to not so much merely independence, but also the ability to make properly reasoned decisions, which are based ultimately, and I think this is the point which we need to reiterate perhaps much more fundamentally, that this is a matter of respect for the rule of law. Both of you have, I think, underlined that. The fact is that we have in Zimbabwe as elsewhere, not only the broader considerations of independence in the sense of respect for proper behavior, etc., but also very specific norms. And in that sense, there is, of course, much room in the sense of possibility of different interpretations. For example, while I agree totally that the removal of Tony, Judge Tony, was incorrect and contrary to the rule of law, at the same time, I have personally very strong views as to whether I agree with his opinion on constitutionality of the amendment to the Constitution. The Constitution was amended properly, and yet he obviously indicated that he would give, and he indicated this before the judicial decision, that he would disagree on the grounds of general principles, which he produced from judgments made in India. Very interesting arguments, but fundamentally arguable. And therefore, in a certain sense, the anthropology, as it were, of that decision, and that was, I agree very much with Alex, the seminal change. The removal of Gubby was the thing which really broke the possibility of the rule of law. And from then, the process of undermining the rule of law has gone on and on and on. But I think that what happened there is you can see the differences in terms of the possibility of argument which are properly judicially based, but which lead to great differences. My view is that in a sense, because I have always believed that the taking of the land by was a criminal offense. Historically, it's justified in the Privy Council because one of the arguments which was presented there in a different anthropological situation was that the right of the indigenous people to have a right, a title to land was, as the Privy Council put it in 1919, uncivilized. And so one can see that there's enormous range of possibility of argument, but at the same time, the fundamental thing is the respect for the rule of law itself. The Constitution as the fundamental law, but also the conventions of proper behavior, as it were. And I think this is where, in a sense, we have gone very wrong. But of course, unfortunately, the atmosphere, which has been discussed endlessly in Zimbabwe for a very good reason, is now much more universal than it might have been. We're living in an age where in the United States, the so-called mature democracy, the rule of law and behavior, civilized behavior, most recently the appointment of judge to the Supreme Court, has broken all of the old rules. So we live in a very dangerous era, I'm afraid, not only in Zimbabwe, but more generally. But thank you very much for raising and pointing out and clarifying a lot of the issues. Thank you very much indeed.
Thanks, Reg. Thank you very much. Musa Kika.
Thanks, Dr. Mandaza, and thanks, Dr. Alex and Dr. Thompson for those illuminating presentations. I think I couldn't agree more really with what the two presenters have shared, and I won't subtract anything at all from what they have said. But 2 points. The first one being the issue of indicators that was being raised by Professor Alex. And what struck me was one of the indicators that he has mentioned, the issue of dissenting judgments. I find this particularly interesting myself because this actually formed part of my master's thesis. I looked at the cases of our Constitutional Court from its inception in 2018. By then it was 2017. So I was looking at that period of its existence and the jurisprudence that is emanated from that court. And part of that was to assess how many
We've lost you, Musa.
Musa, come on.
carrying
Get that
judgments
technology working, man.
we have, and how many dissenting judgments did we have of the many cases emanating from a very constitutional court agreeing on.
Carry on.
Okay, great. So I was struck by the depth of dissenting opinions, even concurring opinions from that court. And to me, that was worrisome. It rang a bell to say we can't have 9 judges over a period of 5 to 6 years agreeing on almost everything. That simply tells you there's something odd. So I just thought I would highlight that. The second issue is, we speak of lack of judicial independence. We speak of challenges around, the manner in which our judges write judgments, for instance. I think one dimension that I would not divorce from issues of independence is the issue of merit. I think this issue now and again comes up when you interrogate the judiciary in Zimbabwe. For instance, a lot of us senior lawyers believe that the best of our jurists are not the ones who are on the courts. Of course, we do have some who are really good, but a number of them are on the bench without having practiced law at any point in their careers. And I think that actually does have a bearing in the manner in which a judge approaches their work or approaches particular cases. It's a difficult one, perhaps a slippery slope, but I think it's an important concept that we also ought to interrogate when we are looking at concepts of judicial independence. I think it'll be much more harder, for instance, to corrupt an individual who has practiced for a bit of time, who has had experience on the other side, and who has done it extremely well. So I think the issue of merit also should feature in the discussion. I just thought I would flag those two aspects, Ibo. Thanks.
Thanks, Musa. Thanks very much. I see some chairs left, is it? I'll take Jonathan Moyo. Jonathan Moyo. Karibu, bwana. Jonathan. 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 Tony, are you ready? Tony, are you ready? Tony Rila? Tony?
Thank you. Thank you. And thank you to the panelists very much. I think that was a comprehensive diagnosis of the disease. And that's very important. But I'm interested in treatment. I think one of the rationales behind the dialogues is, so, under that old phrase, what is to be done? And that's a really complicated problem. Ibo referred to it in the beginning. What do you do when the diagnosis tells you that the offending organ is diseased? Now, there's two stages to this in my view. One is I've been struck for many years that the lawyers talk often about bad judgments, and they talk about judgments that essentially reflect political interests. And I'm struck by the fact that there has been no comprehensive audit of judgments. I mean, some of us who work in the non-legal field get audits all the time. We get told how we can spend our money and are projects working well, and we get audited to 5 decimal points. Why is there no audit of the judges? That's my first point, by their peers. So in the sense that what you reflect to the world is the, I don't know what the word is, the capability or the merits that Musa is talking about. Are these judgments meritable, if there's such a word? The second thing is that if one was to do that, and one was to discover, and Musa's pointed out, the lack of dissenting judgments is a very alarming function. It suggests that all these people all the time have exactly the same view, which seems to me completely unusual in Zimbabwe. If that audit were to show that these judgments were A, without merit, and B, without any exercise of impartiality and independence, what do you do about them? Because the focus of these discussions is the Zimbabwe of the future. When are we going to change? And when we change, what do you do about judges? We're all sitting here watching the US elections where Donald Trump has now elected a largely conservative bench. And of course, Joseph Biden will win, and then he will be hamstrung by a bunch of judges. Now, I'm not suggesting the American Supreme Court is without merit. I'm just suggesting that they may have views that might not concur with the majority. I'm wondering, in your diagnosis and your disease, what do you do with judges who've shown no impartiality and no independence? And what do you do with them when you enter this transition? And what role would they play in a new democratic Zimbabwe? And I don't believe, and I've seen some of the comments, that they need retraining. My suggestion is that many judges don't need retraining. They need something else. Thank you.
Thanks, Tony. Is there anybody else? Hand up. Jonathan Moyo? Jonathan? Okay, I'll have some questions, Alex and Thompson. You made reference in the contrasting situations of Opul Chungono and people like Henrietta Rushwaya and others. Others coming into court like Chungono in leg irons, and others coming in the Range Rovers and so on and so forth. Is this has to do with the judiciary or with the law enforcement, the police, the prison services? That's one. The second question I wanted to ask, and hope that you deal with it as you react to the various comments made, and also in summing up, as you should after this. We want a more succinct and explicit recommendations as to what can be done now. Tony made reference to transition, but what is it that we can do now in terms of ensuring or even preparing for the transition, as the Kenyans done? Are we going to ask the judiciary to resign and reapply as happened in Kenya? I'd hope to get my friend Willie Mutunga on board, but I think he must have traveled because he didn't respond. I'd also asked to get Tuli Madonsela and other jurists to come on board and try and inform us in terms of the practice in South Africa and Kenya, in Nigeria. But I think it's a very important point, and I think that's the import of this discussion, is to end with some kind of even tentative recommendations as what has to be done about what is clearly a very bad situation. So I'll start with Thompson.
Thank you very much. On the aspects of what needs to be done, I think I should perhaps start by mentioning the aspects of cultivating political will. And reason why I say cultivating political will, even of the current government, to ensure independence of the judiciary, is that it may be self-defeating to give recommendations that assume, the coming in of a new administration. If you couch your recommendations based on the idea that they may be coming in a new administration or government, this may set up, I think, some disappointments as far as making sure that our judiciary is independent. So cultivating political will in this regard is to try, through all means, as what has been done before, to cultivate within even the current government, to ensure that they know that they have an interest in an independent judiciary, that one is not in power forever, that where there are allegations, for example, of impartiality or of lack of independence, that they take these aspects more seriously. That is the first recommendation which I give. The second one regards aspect, again, revolving issues of training of judges. I particularly note that one of the persons who have intervened said perhaps training may not be the solution when it comes to certain judges. To a certain extent, I agree. But also, if we are to take note of the point which I said, that sometimes the lack of impartiality or perceived independence, real or perceived independence of a judge, may also be an issue of socialization, issue of psychology, an issue of their training that is actually depriving them the ability, regardless of the political influences that may be present, for them to act in a particular manner. So I would also recommend that it is important for continued training of judges, particularly here, the Judicial Service Commission. I think it should give more recurring or even yearly judicial colloquiums, or even at a more rate, to make sure that our judges are continuously reminded of this particular important aspect of judicial impartiality and independence. And finally, as a final recommendation, I would say that Zimbabwe is bound by international law treaties, the African Charter, which are regional, and the International Covenant on Civil and Political Rights, which are binding on the government of Zimbabwe. And there are special rapporteurs, for example, on the judicial independence. We have been constantly making invitations to come to Zimbabwe and give an assessment, or have some contribution on the aspects or comments on the issues of judicial independence. And those invitations remain pending. Many states accept those invitations and allow them to come. Why is it important at the international level for the government to accept those invitations? Because from the invitations of the UN special rapporteurs, when they come and then recommendations are given, I think in a way, at least in my view, in a way, it gives external, or perhaps if I may say, non-interested individuals to also have a bite at this. Perhaps as a society, maybe when it comes from other non-politically interested individuals, those can be seen as recommendations that are neutral. Those are some of the recommendations which I will give at the moment.
Thanks, Thompson. Thanks very much. Alex?
Okay, thank you very much for that, and thanks, Thompson, for the contribution that you've made, and also for the questions which we have received, including those we are seeing in the chat box. Thanks, Musa, for that confirmation. The problem of dissenting judgments. Once you see a lack of dissenting judgments, it's not just an isolated problem, but a systemic problem. Then you realize that you are dealing with something which is very, very dangerous indeed. And I have no doubt in my mind that it's one of the more important signs of the capture that has taken place. And it's important to understand the reasons behind it. Is it because they are corralled and coerced into agreeing on a particular decision? Or is it because, as you pointed out, there's just a lack of merit and incompetence? The audit of judges that Tony has mentioned, it's a good point. I remember having a very interesting discussion on Twitter with one of my colleagues there on Twitter, and he's from the accounting auditing profession, and he was making some very valid points similar to what you were saying. And as a lawyer, you start thinking, oh, how does this impact judicial independence? But actually, it shouldn't. I think that it should be proper for judges to be audited on how they're performing and how they're doing. It's important. It shouldn't affect their independence. It should enhance the quality of what they produce on the bench. I think that's an important one. Now, as to what's to be done, a question that has been raised both here and also in the chat forum. Well, you know what? I think that we need to, first of all, acknowledge and accept that we have a political problem. The problem of judicial capture is not a technical problem that can be resolved by getting judges together into a room and starting to teach them to do this and that. No, this is a political problem. It was a political problem during the colonial era. It was part of the whole package that was fought in order to ensure that there is change. And of course, we have seen that when the new government came in, it retained a lot of the judges that had been appointed from the colonial era. And that there was a reason why I mentioned that point, that it's possible to have the same people, but perhaps to even have them behave and conduct themselves in a very different way, if they are allowed a professional environment in which to perform. You will be surprised that a lot of the judges who are performing dismally at the moment, or who are perhaps appearing as if they are captured individually, if you give them an environment in which they can perform freely, they will do a much better job than we are seeing at the moment. So for me, we have a political problem, and it is the political problem that needs to be resolved. And remember, when we talk about judicial capture, we are also talking about the capture of ZEC, the Zimbabwe Electoral Commission, the capture of the Zimbabwe Anti-Corruption Commission. We are talking about the capture of various other institutions, in the country, the capture of the police, the capture of all these different institutions. So let's not look at the judiciary as an isolated problem, where we say, okay, so how do we fix the judiciary? No. It's how we fix Zimbabwe. It's how we fix the political problem that Zimbabwe is facing at the moment. The problem that we have, the changes that happened in the 2000s, those problems, remember I said it was a political decision which was made in order to create a court which would legalize and legitimize a political strategy, a political objective, which was to take back the land. They created a court that would allow for that to happen. So we have a political institution, a political referee, and if you are going to change things, you've got to deal with the political problem that is the elephant that we have in the room. Then, of course, we have, the style of leadership by Justice Malawa. I have to raise my hand and say, in 2016, when the succession of Chief Justice Judicial was being discussed, I really did have hopes that Chief Justice Malawa and Chief Justice Malawa would, have a properly new dispensation for the judiciary. And I have to say how wrong I was, and as indeed many other people, because we thought that he would take a very different approach. But I'm afraid to say, with all due respect, given the things that we have seen, given the things that we have had, given the way the handling of the Justice Zimbabwe case has demonstrated, and indeed the other complaints that we have seen about the running of the Judicial Services Commission, it looks to me like this could be the worst constitutional Supreme Court in our history. And for me, Justice Malawa is due to retire when he reaches 70. I don't know whether that is next year. This has to happen. We might get a worse person or someone else, we don't know. But he has to go. And I'll tell you why. Constitutional amendment number 2 is being debated right now in Parliament. Why is it being done? Because one of the reasons is they want to change the retirement age of judges. It will allow judges who are 70 to stay on until they are 75 for every year, as long as the president okays them with a medical certificate. And that's a route for Justice Malawa to continue as the Chief Justice of Zimbabwe. If you don't want that to happen, challenge constitutional amendment number 2. A lot of people talk about challenges, talk about issues, but when it comes to the crunch, when it comes to standing up for the right things, they don't do it. They don't get involved. If you allow constitutional amendment number 2 to go through, then I am assuring you, be rest assured that you're going to have the leadership of Chief Justice Malawa and the kind of leadership that is being complained about for the next 5 years. Finally, I think that there should be gatekeepers. They should be gatekeepers that used to play an important role in the past. The Law Society of Zimbabwe, I'm disappointed in the way that it has been approaching issues, especially concerning independence of judges. Sometimes they come up and say some positive things, but whenever you see this mutilation of the rule of law, they're all too silent. And I think that's a disappointment. The academic community used to play an important role, the law faculty and the UZ used to have a very important voice. The academic community at the University of Zimbabwe, they used to play a very important role in being the sort of the guardrails of our democratic process, nascent as it was then. I think this has gone out it needs to come back, it needs to change. And of course, civil society, I think that civil society needs to do more. Stand up, for people like Justice Dewey. Stand up against the injustices that are taking place with people like Hope Ochimono. Stand up for the judges, fight against the judicial poverty, which is causing the capture that we are talking about.
Thompson, you want to say something? Thompson, I see your hand up.
Yes, I just wanted maybe to re-emphasize and echo the points made here, but again to highlight that while I totally agree with Dr. Magaisa that we have a political problem, I think it is still important to not or to approach this as from a multidisciplinary standpoint, to say that even if it is there may be a political problem, politics contributing to a certain extent, there are other, maybe to a large extent, so to say, there are other factors that are also contributing. The reason why I'm saying that, even when we look at your presentation, Dr. Magaisa, there was a point where, from the history of the judiciary of Zimbabwe, the judiciary of Zimbabwe was better, regardless of existing other factors that were there, which could have captured the judges. But because perhaps of the crop of the judges who were there, how they were approaching matters, they were able perhaps to stand their ground. So in approaching or trying to find solutions, for example, when we're saying there is political capture, I encourage perhaps to approach this matter, not only from a political standpoint, because the moment we do that, maybe I may get it wrong, but I feel as if the approach would then become, we are waiting, for example, where a certain good man would come into power, or where a certain good administration would come into power and change things, which is, in my mind, I'm thinking, let's cultivate political will. Let's emphasize why it's important for everyone to have an independent judiciary. Even with the existing, shenanigans that are happening, let's try to see if there is a way to make sure that our judiciary is independent.
Thanks a lot, Thompson. I think the both of you, Alex and Thompson, have ruled convincingly that we have a problem, that the capture of the judiciary is not a myth, it's a reality. But more important for us from political economy, that the pathologies of the judiciary are not unrelated to those of the state and politics. But then, as you just hinted in your last remarks, Thompson, is there a chance that in the old and conventional formulation of an accountable executive and a vibrant legislature and a fiercely independent judiciary as a soul of the nation, whether we can expect from the judiciary, which is staffed by people, some of whom we know, some of whom we grew up with, who could rise beyond the politics, have the courage to stand up as others have in the past. We remember very eminent jurists like Justice Gabe, Justice Ibrahim, Dubuchena. We have had some luminaries who have stood and suffered for it. Is it possible within the judiciary as a whole, and as Alex has indicated, even the law society? Why are we so quiet while the soul of the nation is being battered? Why are we so quiet? Alex, you said, well, there's been deafening silence in the law society, in the academia, the university. Well, we're here. That's why you're here on this platform. This is one policy dialogue forum where we're trying to raise these issues as we are. And we want to take it further than this. You raised the point about the international peer group, the international law treaties, the special rapporteurs. Is there any way we can move to try and get them to do something in the interim. But I want to emphasize that it is important that we appeal to a very important sector of our society. We're very robust, at least in terms of numbers and diversity of the legal profession in Zimbabwe. Some of our most eminent politicians are in the legal profession. Can you, our dear lawyers, help us to launch part of the recovery program for our country? And that this is really the last appeal that we make in thanking you, both Alex and Thompson, for preparing so well for this policy dialogue. So well prepared. We look forward to your papers. I think it's become a very important milestone in what we have done so far. And Alex knows what we're talking about since he's been part of this conversation. As we move forward and come to, as part of the struggle for the recovery of the Zimbabwean situation. So I want to thank you again and remind you that we're here 2 weeks' time. We are looking now at the role of the youth in this momentous and very difficult task of getting our society, our country back on tracks. Thank you very much. Thank you to you all who joined us. We had a very good attendance from all over the world. Of course, the lawyers were full up, but so were the general public. Thank you very much. We apologize. The Facebook had some problems, but we will be loading it soon, within the next half an hour on Facebook, and of course, YouTube tomorrow. Thank you very much, and good night.
Oh, Toddy, what shall we do? Sinzinjan.
What shall we do? Vazvababata pamureri pasina rarambo. Vazvabatumbuka pamureri pasina rarambo. Yeah, Toddy, what shall we do? What shall we do? What shall we do?
Toddy, what shall we do?
What shall we do?
Zvinorwadza sei kubinywa newaugere naye. Zvinorwadza sei kubinywa neakabvisa pfuma. Achiziva unawo utachiwana. Ende uchiziva unawo utachiwana. Oh, Toddy, what shall we do? Oh, Toddy,